Hello. The focus of this tutorial is the Declaration of Disclosure, which is Form FL-140. This is a mandatory form. Your dissolution cannot go through without you having served this on the other party. If you are preparing this as part of your petition, it makes sense for you to serve this with all of the original petition papers because it gets it out of the way. I think would probably be the best explanation. Also, you are required to do this within 60 days of filing your petition anyways, so might as well just get it done while you're already filling out the rest of the paperwork. This form does not, and it even says, do not file with the court. This form only goes to the other party. And the purpose of this form is so that the other party knows exactly what financial information you have disclosed. Even in cases where there is no property to be divided and there is going to be no request for spousal support and there is going to be no request for child support, this form still needs to be completed. If you would like to watch or listen to the tutorial for the FL-160, which you should be able to find on this same website, that will help you in crafting a property disclosure in cases where there is no property for the court to divide. But just know that even when there is no property, you can file or fill out the property declaration. You can fill it out in a way that it encompasses community property as well as separate property. So the point of this is that when you serve it with the petition or with the response, because this has to be filed by a respondent. If that respondent does file a response, this has to go with it. You're telling the other party, okay, I'm making a disclosure of this information. Even if that disclosure is that there is no information to disclose, you're making that disclosure. It allows the other party an opportunity to determine whether he or she is going to contest your disclosure. For example, if you forget to disclose that you own something very valuable, then the other party can take that lack of disclosure and ask the court for permission to inquire into your financial situation. So it's important to do this. In fact, it's mandatory to do this, and it's important to do it accurately and thoroughly. Okay, so how do you fill this one out? At the top, as with every other form, put in your name and address. Again, this is for Siskiyou County. The address of the court is 311 4th Street, and the branch name is family/civil. Petitioner and respondent is the same as it always is. These two titles don't change. So if you're filing this with the original, or if you're preparing this with the original petition, put your name as petitioner, respondent is respondent. under these checkboxes, so if this is the petitioner's declaration, then you'll mark that one. If it's the declaration you're filing with the initial petition, then you mark the box for preliminary. If this is the declaration that occurs later in a contested case, close to when the case is wrapping up, then you'll mark final. It is absolutely mandatory that both parties serve a preliminary disclosure. The final disclosure can be waived by agreement between petitioner and respondent, but the preliminary disclosure cannot be waived. So go ahead and just get this done with your initial documents, and it'll help the case move along.